Mr. Roberts. So what time can we work?
My lord, I think not later than 3:30.
Not 4 o'clock.
They must go back, that's the problem.
Okay.
And
And if we're late,
transport,
will we get in trouble if we're late?
then they might miss their...
They were late, when they brought them here.
Yeah.
But after 3.
Yes.
Okay. Yes. I'm proceeding with my judgment. In deciding whether to convict or acquit an accused, the court is obliged to adopt a correct approach. In State v. Shabalala 2003, Volume 1, SACR 134 SCA, at paragraph 15, the court held that the correct approach is, and I quote, to weigh up all the elements which points towards the guilt of the accused against all of those which are indicative of his innocence, taking proper account of inherent strengths and weaknesses, probabilities and improbabilities on both sides, and having done so, to decide whether the balance weighs so heavily in favor of the state as to exclude any reasonable doubt about the accused's guilt. When accused's version is wholly improbable as to be plainly untruthful, it may be rejected as false beyond reasonable doubt. Much was made by accused 1 and 2's counsels on the issue of hearsay evidence in their heads of argument. They had both relied on the judgment in the matter of State v. Glover and others, 2002, Volume 2, SACR 325 SCA, which stated inter alia that it was the duty of the trial judge to keep inadmissible evidence out and not to listen passively. They both conceded that the aforesaid matter was not one that dealt with the provisions of POCA, where hearsay evidence is admissible unless it will lead to an unfair trial. I am acutely mindful of the provisions of POCA and what the court's approach should be when dealing with hearsay evidence. The witnesses who had testified about what they had heard were fully cross-examined, and the accused knew well before they testified what the nature of the evidence was and dealt with it fully when they testified. There was no suggestion that they were prejudiced, and if so, how they were prejudiced. The hearsay evidence relates mainly to utterances made by the following witnesses, or deceased persons, namely Natasha, Michaela, Jared, Peter Meyer, and John Meyer. The state sought to have the hearsay evidence admitted because of the impossibility of calling the said declarants in person to testify, since they are deceased. Many reports by the deceased were made to different witnesses, and there was some measure of corroboration for it, and all of them were subsequently murdered by members of the group. At the end of the day, the hearsay evidence, let's say in 1 or 2 instances, was not crucial to determine the guilt or non-guilt of the accused, since most of it were confirmed by some of the former accused and by accused number 3 herself. The evidence does not directly implicate or identify any of the accused before court, and was tendered in circumstantial evidence to be taken into account by this court. The prejudicial nature, therefore, is negligible. Because there is direct evidence as well as circumstantial evidence in respect of most of the charges, the hearsay evidence would simply serve as a supporting role. The prejudice that the accused may suffer in those circumstances, if the hearsay evidence is therefore at least minimized to such an extent that its admission would not render this trial unfair. Strictly speaking, the issue of hearsay is no longer really applicable, since most of it was corroborated by accused number 3 when she decided to come clean. Counsel for all the accused, save in 1 or 2 instances, considered that they were no longer persisting with that argument forcefully. The only exception related to what accused 2 had told accused number 3 about what accused 1 had said about Michaela wanting to leave the group. The further hearsay evidence related to whether the group had used the money that they had obtained after the murder sprees that took place on accused number 1 whilst he was in hiding. The state had initially contended that Miranda had testified about it. She did, but it said that she was told that by LaRue that he had taken the money to accused number 2. She herself did not have personal knowledge about it, and had sought to rely on what she was told by LaRue. LaRue himself did not testify about that. Let me repeat. LaRue did not testify about that, and accused number 3 herself was not aware of that. The state then considered that there was no evidence about that, and that accused 1 should be acquitted in respect of counts 22 to 30, which I agree with. I now deal with the existence of a ministry called Electus per Deus. Section 1 of POCA states that an enterprise includes any individual, partnership, corporation, association, or other juristic person or legal entity, and any union or group of individuals associated, in fact, although not a juristic person or legal entity. Clearly, this is a wide definition of what an enterprise entails. I am satisfied that based on the evidence before me, that Electus per Deus, or what Electus per Deus were doing, fits neatly into a description of an enterprise. Both LaRue and Charles Truter were adamant that the nature of the activities that surrounded and related to accused 2 constituted a ministry which had a specific name called Electus per Deus, and a specific purpose being looking after the ex-Satanist accused number 2, in not only in a spiritual sense, but also in a physical sense. The ministry included accused 2's alleged involvement with an orphanage, sending people overseas and supporting other people, requiring financial assistance to protect them from the Satanic Church. All members of the group coincidentally had the Electus per Deus tattoo somewhere on their body. Most witnesses testified that accused 2 told them of the existence of an orphanage for children. And I've already pointed out what contributions were made by accused number 1, John Barnard, and Candace Ridgewick. Accused 2 was assuming the role of a leader of the ministry by baptizing people, writing sermons and prayers, and even performing marriage ceremonies. Everything that happened at the high days had the distinct features of a ministry at work. Accused 2's vehement denial of the existence of any ministry is to be expected, as any admission thereof would certainly provide evidence of a motive to retaliate and take revenge against Ria for abandoning her. Other witnesses referred to paying tithes, as referred to in the Bible, to accused number 2. Accused 3, after initial bare denial in evidence, confirmed the existence of the group, of which the leader was accused number 2, and the second in command was her mother, Miranda. Of all the people involved in the criminal activities, the person who had by far and the most to gain from taking revenge of Ria was accused number 2, since the other members of the inner circle had either no or at least very limited personal involvement with Ria. Put differently, if Ria was taken out of the equation, none of those offenses would have been committed. It's also clear that after the evidence of accused number 3, that accused number 2 had received all the proceeds of the crimes and all benefits therefrom. I'm therefore satisfied that it has been proven that there was this ministry that existed and the enterprise. LaRue, Barnett, and de Villiers corroborated each other that in respect of the murders, the identification of the victims, the conspiracy and planning and the report back occurred at One Kosana flat, which is accused 2's flat. What is of significance is the fact that these meetings were always held, firstly, at One Kosana flat, and secondly, in the presence of accused number 2. There is further corroboration for LaRue and Barnett therein that de Villiers testified that during the meeting he recorded, or the meeting that he had recorded, they had a general discussion about the murders. That meeting took place at One Kosana flat, in the presence of accused number 2. Those multiple report-back meetings, which were overheard by LaRue, Barnett, and de Villiers, are the only explanation of their detailed knowledge of incidences where they themselves were not personally involved in it. I am satisfied that the probabilities favor the state's case that there were in fact various instances of report-back meetings and or general discussions of previously committed murders. Those multiple report back and planning meetings were confirmed by accused three's evidence. It is not disputed by the accused that Ria and most of the individuals who attended Ria's course, KYE and KYS, at some stage received threatening messages on their cellular phones. Accused 1 had also said that he had received threatening messages from witches of the Satanic Church, but his evidence is extremely doubtful since he was trying to justify why he went and remained in hiding after he had faked his death. The obvious question is who would have sent those threatening messages and for what purpose? Those threatening messages were connected to Ria, as it was directed at her personally and at individuals associated to her ministry and courses. One of those messages revealed intimate knowledge of the members associated with Ria, in that it specifically referred to possible future victims identified as being either a hairdresser, a traveller, a cyclist, or the boy Vincent. Each one of those references related to an identifiable individual who took part in Ria's courses, respectively being Sari Volbrecht, Chris Black, Nigel Blackmore-Reed, and Vincent, being a reference to the son of Pastor George Snell. Those messages revealed not only intimate knowledge of the murders, but in one case, even prior knowledge of a murder that was still to take place, namely that of Ben Dixon. In this regard, Ria's evidence was clear that shortly before the murder of Ben Dixon, she received a message asking her whether she had said goodbye to Rex, Ben Dixon. The message could not only have been forwarded by someone who had prior knowledge that the murder was about to be committed. Miranda, who testified that she and accused 1 had committed the murder, denied that she was the author or sender of the message. Accused 1 also denied that he had authored or sent the message. In my view, the only person who could have been the author thereof was accused number 2. This inference is also in line with the evidence of LaRue that accused 2 created a fake girlfriend for him, and he caught her out that she was the person sending the SMSs to him. The same applies to the other imaginary friends created by accused number 2 for Candace Rejovic and Miranda, who denied it in line with her evidence to exonerate accused number 2. However, accused number 3 admitted that the authors of those anonymous threatening messages were accused number 2 and Miranda, and that she had sent one herself. I now proceed to deal with the specific charges, and I'm starting with count 1, which is the racketeering charge under section 21E, participation through a pattern of racketeering activities. All of the accused denied that count 1 was proven by the state. I disagree. Section 1 of POCA defines pattern of racketeering activity means that it's the planned, ongoing, continuous or repeated participation or involvement in any offences referred to in Schedule 1 and includes at least 2 offences referred to in Schedule 1, of which one of the offences occurred after the commencement of this Act, and the last offence occurred within 10 years, excluding any period of imprisonment. After the commission of such prior offences referred to in Schedule 1. Schedule 1 refers to murder, rape, kidnapping, arson, etc. Racketeering is not only limited to monetary offences, but includes the ones that I've just mentioned. This is a classical example of how a racketeering enterprise operates. I've pointed out that the state is required to prove, as far as accused 2 is concerned, that whilst managing an enterprise, the accused directly or indirectly participated in the conduct of the enterprise affairs through a pattern of racketeering activity. I am satisfied that from the evidence laid before me, that each of the accused committed directly or indirectly 2 or more of the predicate offences as part of the planned and ongoing activities of the enterprise. It's clear from the evidence that the enterprise operated in a I struggle to pronounce this word, hierarchical structure, with accused 2 being the leader and the mastermind, and Miranda being the second in command. They gave the direction of the actions of the enterprise as well as instructions to the subordinate to execute. Similarly to the CEO of a company, different employees have different functions and tasks to execute to the benefit of the company. In casu, The same applies in that accused 2 and or Miranda would issue orders or instructions for the others to comply with. The faking of accused 1's death as well as the appointment murders are prime examples of different tasks being given to different members of the enterprise in order to achieve the ultimate goal, being the process of crime. Accused 2 was at the top and the mastermind had received all the benefits and proceeds of the crimes that she was giving, and she was giving instructions to the subordinates, and who made sure that she never dirtied her hands by becoming directly involved in the criminal activities of her subordinates. She directed all criminal activities from her headquarters at 1 Kosana flat. She was at all relevant times aware of all the criminal activities and was fully briefed after each criminal endeavor. Miranda was second in command and would take command at the various crime scenes where accused 2 was not present. Accused 3 and the former accused were the foot soldiers. It is not strange that they had changed their modus operandi from revenge killings to obtaining money to sustain the mastermind's lifestyle and pay her medical bills. It is clear from the evidence and the close relationship between the accused and that the commission of the predicate offences through a pattern of racketeering activities by the accused, the existence of an enterprise, and therefore the commission of those offences in respect of all 3 accused have been proven beyond reasonable doubt. There was overwhelming evidence about this, which is not necessary to repeat. Now I'll deal with count 2, which is the managing enterprise, section 21F, and knowledge. It's clear from the evidence that accused 2 did not only have the knowledge, but was in actual fact the driving force, mastermind, and initiator of all the offences set out as per the indictment, mainly for her sole benefit. She manipulated and influenced all the decisions to set out on a path of violence that inter alia resulted in the death of 11 people. Together with Miranda, they managed the actions of the members of the inner circle of electus Bedeus so as to give effect to the goals of, firstly, taking revenge on Ria, and secondly, obtaining and or securing alternative sources of income through criminal activities to wit, the predicate offences. Culpa as a form of mens rea is sufficient for a conviction in respect of this charge. I'm satisfied that this charge has been proven beyond reasonable doubt. I now deal with counts 3 to 5. The evidence linking the accused to those offences is that of LaRue Stein, as well as accused number 3. According to LaRue, he was requested by accused 2 to research various methods of bomb making. He sometimes, with the assistance of accused number 2, assembled various different types of bombs. Some of those bombs were later on disposed by his mother Miranda and accused 3, who confirmed that. Accused 3, however, explained in detail how the group began to target the members attending Ria's course at Rama Court on accused 2's instructions. She confirmed that they were involved in the breaking into Pastor Nell's vehicle, the so-called hold-up of Blackmore Reed, the faking of injury to accused 2 after a presumed gunshot, the slashing of Natasha's vehicle's tire, as well as a fire at the Lighthouse Church. She also confirmed the placing of the threatening letter secured in a plastic cover written by accused number 2 and addressed to Ria on the gate of the church. Relating to the incident on 4th July 2012, LaRue stated that accused 1 and Miranda and accused 3 left during late afternoon and only returned after dark. He stated that the same procedure was followed in respect of the incident on 11 July 2012. Similarly, in respect of the petrol bomb at the Lighthouse Church, he testified that accused 1, Miranda, as well as accused 3 were involved in it. Accused 3 confirmed his evidence in this respect. She further stated that her mother was manufacturing these so-called fertilizer bombs and that she and accused 1 were at the premises. Accused 1 jumped the wall and she was handing him the wrapped packages of fertilizer bombs as well as the petrol. They were interrupted and somebody exited the house and ran away. This evidence is confirmed by the objective facts as well as the evidence of Sandri Volbrecht, Annemarie Scholz, and others. In respect of count 4, the explosions on the 11th of July 2012, LaRue stated that these bombs were placed and activated by accused 1, 3, and Miranda and Michaela. It is clear that accused 3 was on the scene, specifically tasked with to be on the lookout and to participate in the conference call to warn the others if anybody was approaching the crime scene. The only reasonable inference is that all the accused were involved in it, or at least at common purpose with the actual perpetrators. This also makes sense that the initial threats increased in seriousness until it culminated in the murders that were committed. Nobody else had any interest in or potential benefit from the threatening messages, except the people involved in the murders, and this is corroborated by the evidence of accused number 3. The accused were therefore either involved as the actual perpetrators, co-conspirators, on the basis of common purpose, and or as accessories. It was contended on behalf of the accused that these were splitting of charges. I do not agree, and am of the view that the purpose of sentencing, or that for purpose of sentencing, that these 3 charges may be taken or may be treated as one. These various incidents were not random acts of violence, but clearly formed part of a coordinated strategy to cause injury, financial and or emotional, to Ria. Accused 3 explained that Ria could not be targeted personally due to the fact that she had the maternal rights of accused number 2. Therefore, the decision was taken by accused 2 to target people close to Ria, and in this indirect sense cause harm to Ria. The only person who could benefit from these offences was accused number 2, as part of an orchestrated attempt to take revenge on Ria and or individuals associated with her. I now deal with the intimidation charge in contravention of Section 11B of the Intimidation Act 72 of 1982. According to the indictment, the accused had been charged with a contravention of Section 11B, read with Section 12 of the Intimidation Act. The state is no longer relying on the provisions of Section 1, subsection 2 of the Act. However, it is clear from the direct as well as circumstantial evidence that the state has proven the commission of the offence in terms of Section 11B without the necessity to revert to the provisions of Section 1, subsection 2. The majority decision of Moyo and another, the Minister of Justice and Constitutional Development and others, 2018, Volume 2, SACR 313 SCA, declaring Section 1(2) of the Intimidation Act unconstitutional, is therefore not applicable in this matter. And I'll deal with counts 6 and 7, which is the murders of Natasha Berger and John Bonzaya. According to Miranda, those murders were committed by accused 1 and Michaela. The scene was first scouted prior to the murders. On the day of the murders, accused 1 and Michaela gained access to Joy's flat by pretending to have a gift for Natasha. A written message was left at Natasha's flat to come to Joy's flat immediately upon her arrival from work. Once Natasha arrived at Joy's flat, Michaela hit Natasha on the head with a hammer, after which she got cold feet and ran out. Accused 1 then continued with the attack on her. Joy was subsequently also attacked and killed by accused 1 by slitting her throat. Accused 1 collected the weapons and evidence on the scene in a plastic bag which was dripping blood as he returned to the vehicle. This is objectively confirmed by the scene photographs. After the feedback given by accused 1 and Michaela, Miranda assisted them in getting rid of the evidence and by cleaning by cleaning the vehicle and by telling them not to inform anybody of the murders. According to Arana, accused 2 called her prior to Natasha's murder, eliciting from her personal information concerning Natasha. Accused 3 corroborated the version of Miranda, except as far as the hitting of Natasha Berger by Michaela is concerned. She, however, added that she was part of the scouting party who went to Natasha's flat prior to the murder. She was also part of the previous attempt to gain access to her flat. At that stage, she was disguised with a wig, armed with a taser gun, and tried to access the flat. She spoke to the deceased under the pretext that she was looking for her cat and wanted to enter the property. The plan was that once she was inside, that she would continuously use the taser gun on her to immobilize her. Once immobilized, she would have called accused number 1 and Michaela, who were armed. This plan was unsuccessful, as the deceased did not allow her into the property. On the day of the incident, accused 3 did not accompany them. She, however, confirmed the feedback report given to accused 2 by accused 1 and Michaela after the incident. According to the plan, wrapped gifts were taken under the pretext to give it to Natasha, as confirmed by Miranda. She confirmed that the second deceased, Joy, wrote a letter to the first deceased to come to her flat. It was also confirmed that after the initial attack by accused 1 on Berger, Michaela ran out of the flat. Both the deceased were then killed by accused 1. Upon their return, accused 2 instructed accused 3 to rinse the murder weapon with chick in order to get rid of the evidence. According to LaRue, he overheard a conversation in respect of accused 1's involvement in the murders. This evidence corroborated by the evidence of Miranda, as well as that of accused number 3, that accused 1 and Michaela committed those murders. It was mentioned that Joy was at the wrong place at the wrong time and had to be killed. Her death was referred to as collateral damage. Further corroboration is found in the objective evidence concerning the flat where the murders were committed and the handwritten note found at the scene of the crime. I now deal with count 8, which is the death of the murder of Reginald Reg Dixon. Miranda testified in detail how she and accused 1 planned and murdered Ben Dixon. They found the victim under false pretenses that she was a warrant officer Skuman of the police. Under the pretext of a meeting concerning the death of Natasha, they lured him to come to the gate. Accused 1 was dressed in police uniform and she in formal clothing, which was used as a decoy to gain access to Ben Dixon's premises, which was, according to Ben Dixon's wife, always locked with a padlock. Once inside the premises, and whilst Ben Dixon's attention was focused on Miranda, accused 1 attacked the deceased from behind with an axe. Miranda also stabbed the deceased multiple times with a knife. It is now clear after the about turn of accused 3 that she was part of the murder. Once again, it did not happen on the first attempt as planned, since accused 3 was feeling nauseous. And the understanding amongst the group was that if somebody was not, or was for whatever reason not willing to proceed, the decision would be accepted and the plan not executed. On the second attempt, she, Miranda, and accused 1 posed as police officials wanting to interview the deceased in connection with the murder of Natasha. Accused 1, who was dressed in a police uniform, disguised himself with a red wig, scarf, lipstick, according to Miranda, and sunglasses when they entered the boomed-off area. Miranda disguised herself by wearing a wig and cheap but neat clothes and deckies, which she bought at pep stores, with the intention to dispose thereof afterwards. They rented the vehicle from Avis for this purpose. They even placed false number plates on the rented vehicle. Accused 3's presence in the vehicle was also part of the plan, as the deceased would more easily be prepared to allow them access if a child was present. In order to lure Ben Dixon to the gate, she bought a cheap cell phone on which she called the landline. When Ben Dixon answered the phone, she informed him that they were detectives from the police and that they wanted to talk to him. The deceased then opened the gate. Accused 3 confirmed that Miranda, at the stage during the stabbing, pulled up his shirt, jersey, and stabbed him again in the abdomen. This is confirmed by the objective evidence and the condition in which his body was discovered at the scene. According to the Villiers, accused 1 once told him how he had hit Ben Dixon over the head with an axe. This was confirmed by accused 3 and Miranda. The Villiers also testified that accused 1 once bought pig heads, which he used to hit with an axe as a test run. Accused 3 elaborated thereon by stating that the pig heads were also used to practice their stabbing techniques. The Villiers furthermore stated that accused 2 told him that accused 3 also got some stabs in. Accused 3 testified that the only time she stabbed a person was at Michaela's murder, and she explained that he must have gotten confused with the incident. After the murder, according to accused number 3, they drove back to accused 1's house. When entering the complex, they met Michaela, who stopped to inquire what had happened. When told about Ben Dixon's murder, she was surprised that they actually did it. At the house, the false number plates were removed, and the blood-stained and/or dirty clothing was washed, and they had put on fresh clothing. Subsequent to the murder, on the day of Ben Dixon's funeral, a letter similar to the one found at the Lighthouse Church, together with pieces of flesh, was placed at Ria's front door, forming part of the overarching scheme to threaten and intimidate Ria. Miranda denied any knowledge of that incident. Accused 3 testified that she knew about that incident and that the letter was written by accused number 2. She further confirmed that the meat used came from a pig's head used to practice stabbing techniques in accused 2's bedroom. Her evidence deviated from Miranda's evidence relating to the motive for the killing of Ben Dixon. Miranda said that she hated Ben Dixon because of the way he had treated Ria. Accused 3, however, gave two reasons why Ben Dixon was targeted. Firstly, he was close to Ria, which accused 2 did not approve of. And secondly, because he used a sermon written by accused number 2 as if it was his own. According to the state witnesses, it was well known that Ria regarded Ben Dixon as a spiritual mentor and dear friend. I now deal with count 9, which is the murder of Michaela Valentine. Miranda testified that she killed Michaela with the knowledge and help of accused number 1. She also stated that according to the plan, accused 1 would put medication into Michaela's coffee, which would have the effect of making her sleepy and drowsy. Prior to each killing, she brought cheap flick knives to be used as the murder weapons. A key and remote were given to her by accused 1 in order to gain access to the complex and house. On arrival, she did not enter the complex with her vehicle, but parked it at another complex from where she walked to accused number 1's house. The reasons being that she had on previous occasions visited accused 1 and the deceased with the same vehicle, and she was afraid that somebody might recognize the vehicle. It was not necessary to use the remote as she gained access to the complex when workers at the complex arrived. She found accused 1 had not yet left, but he indicated to her that everything was fine as planned. He then left and she went into the house. She testified in graphic detail as to how she first hit Michaela with a hammer and then stabbed her until she died. She also told her when she opened her eyes during the attack to start praying as she was going to die. After she killed her, she dressed in fresh clothes, which she took with her, and then went back to accused 1's flat at 1 Kosana flat, where they watched DVD movies. The motive for Michaela's murder was to prevent her from spilling the beans on Zach Valentine and the rest of the members of the group, Electus Bedeus, in respect of the murders of Natasha, Joy, and Ben Dixon. The motive was clearly to protect all the members of the group from the possible risk of Michaela going to the police and revealing their involvement in criminal activities. According to LaRue, Michaela was killed on instruction of accused number 2, as accused 2 stated that Michaela was a loose end, which had to be taken care of. This was confirmed by accused number 3. Furthermore, LaRue testified that during a conversation between accused 2 and Miranda, in the presence of accused 3, he overheard that accused 3 also took part in Michaela's murder. Accused 3 has now confirmed this. According to accused number 3, she had overheard the conversation between accused 1 and 2, when accused 1 told accused 2 that Michaela wanted to leave the group. Accused 2 told her after that the conversation what accused 1 had told her. Plans were then made to get rid of Michaela. It involved the receipt of a duplicate key and remote to gain access to the house. The plan was further that accused 1 would prepare the scene, drug Michaela, and leave for work and come back later with the estate agents to discover the body. That would support his alibi. The plan was also that it should look like a housebreaking and robbery. Accused 2 further instructed them that after the killing, they must ensure that the body be kept warm in order to confuse the authorities about the time of death. They also bought cheap clothes from pep stores, so it could be discarded afterwards. Accused 3 accompanied Miranda to the complex and corroborated that they first parked at a different complex and then walked to accused 1's house. According to her, accused 1 was not present at the house. They entered through the garage and followed Miranda up to the main bedroom where Michaela was sleeping. Michaela appeared to be asleep, and Miranda entered and attacked her with a hammer and knife. During the attack, Michaela was trying to defend herself from the blows, but the defensive actions were slow, as if she was drugged. She confirmed that Miranda told Michaela to pray and repent as she was going to die. She also then used a knife to stab Michaela once in the left side of her body. She then told Miranda that she could not continue as her knife was blunt. After Michaela's death, accused 3 pulled a blanket over the body of Michaela and also put on the electric blanket to disguise the timing of death. They then removed Michaela's tablet and wedding ring in line with the plan to stage a house-breaking and robbery. She confirmed that Miranda put on fresh clothing before they left to accused number 2 to report back. They disposed of the tablet and the wedding ring on the way back. Accused 2 was satisfied with the result, as nothing had gone wrong. Having considered the nature and extent and a number of injuries on the deceased in counts 6, 7, 8, 9, 11, and 12, Professor Simon described those murders as crimes of passion, indicating a personal feud against the deceased. This was corroborated to some extent by the evidence of Miranda, as well as accused 3. The evidence of LaRue also corroborated the opinion of Professor Simon therein that all these murders were planned in advance, and that the foundational motive for the killings of the deceased in counts 6, 7, and 8 was to take revenge on behalf of and under the instruction from accused number 2 on Ria. The motive for the killing of Michaela was to prevent her from revealing the group's involvement in criminal activities. It is therefore clear that the deceased in counts 6, 7, 8, and 9 were emotionally connected to the accused due to their prior involvement in the ministry of Ria. I now deal with count 10, which is a conspiracy to kill Joshua Groenewald. According to accused 3, the motive for targeting Joshua Groenewald was because it would have been the best way to get to Ria, as they regarded him as very close to Ria. The evidence of LaRue, de Villiers, and accused 3 is relevant. According to LaRue and accused 3, various scouting excursions were undertaken to determine the whereabouts and daily routines of Joshua Groenewald. These included his workplace, his home, and sports venues. All the accused, including de Villiers and Marinda, were actively involved in the planning and preparation phases. De Villiers furthermore testified in respect of the involvement of accused 1, more specifically, how they even conducted the test run on one evening, which was interrupted by a power interruption. He furthermore testified that accused 2 gave certain tips or pointers as to how Joshua Groenewald could be killed. In this regard, he also testified of a recording that was made with the help of the police, during which the planned murder of Joshua Groenewald, as well as other previous incidences, were discussed by members of the group. De Villiers, LaRue, and accused 3 testified that LaRue was instructed by accused 2 to dig various graves at different places, specifically to dispose of Joshua's body once he was killed. According to accused number 3, the plan to kill Joshua Groenewald was abandoned on instruction of accused 2 after de Villiers had disappeared. She was concerned that he might inform the authorities of the plan. Joshua Groenewald himself testified that he was visited by accused 1, a discovery agent under a false name of Jason, at his place of employment, under the guise of providing short-term insurance, but in fact eliciting valuable information from him to assist with the planned murder. All of these constitute executive acts for the purposes of the conspiracy to kill Joshua Groenewald. I now deal with counts 11, 12, and 13, which deals with the murder and robbery of the Meyer couple. The evidence of Marinda implicates both herself and accused 1 in the commission of the offences. To that extent, she also corroborates the evidence of LaRue and Barnett that the 2 of them were involved. Both LaRue and Barnett implicate themselves, not only in respect of the planning of the offences, but also to the extent that they had common purpose in respect of the robbery. The evidence of LaRue and Barnett goes further and implicates both accused number 2 and 3 as well. This was confirmed by the evidence of accused number 3 to the extent that she was involved with the scouting, the actual visits to the house, as well as the murders. Accused 1 is implicated directly by the evidence of Marinda and accused 3 as being the actual attacker. He is furthermore implicated by the evidence of LaRue and Barnett in respect of him being part of the planning, scouting, and feedback. Noteworthy also that after the Meyer murders, the planning was done for the disappearance of accused 1, especially once it was known that he had to submit himself to a polygraph test. Accused 2 is implicated to the extent that she was a person who initiated the whole incident by requesting them for proposals on how to get money. She was part and parcel of the planning, the feedback meeting after the commission of the offences, which again were held in her flat, in her presence. The money that was robbed was handed over to her immediately after the incident. She handed a portion of the robbed money to Barnett as payback for his involvement in coming up with a plan to rob the Meyers. Accused 3 confirmed that she accompanied LaRue, Marinda, and accused 1 to the business premises of the Meyers. This was already considered as a possible opportunity to commit the crimes, but it was not executed by LaRue and accused 1. They then decided that it would be best to do it at the Meyers' house. For this purpose, they devised a cover-up story of government employees from the Department of Trade and Industry to make available funds for the development of the water park in KZN. They visited the house on more than one occasion and gained entry to the house where the business deal was discussed with the deceased. At one instance, the deceased even took them to a tour of the house. On the day of the murders, accused 1, Miranda, and accused 3 went to the mayor's residence. Initially, LaRue would have accompanied them, but due to the fact that he accidentally shot himself in preparation for this mission, was hospitalized. Nicholas Meyer testified that prior to the murders, he observed accused number 3 during a meeting at his parents' house. Although he originally thought she was a boy, he later identified her as accused number 3. He stated that she was the same person he observed in the motor vehicle when Miranda and accused 1 visited their home on the 26th of November 2015. He stated that he also observed her in the motor vehicle when the same three persons arrived at the house to drop off a brown envelope purporting to be from the DTI. Once again, they were fully prepared for the mission with knives, firearm, cable ties and gloves. Once inside the living room, Miranda inquired as to why there was no smell of food like the previous visit. The deceased explained that their son and his girlfriend had left to collect takeaway food. Miranda then produced a firearm and held them up in order for accused number 3 to cable tie them. They were trying to locate the whereabouts of the safe from the deceased. Accused 3 removed their wallets and cell phones from their pockets. Out of the blue, accused 1 was pacing up and down, attacked the deceased, and started stabbing them. It even surprised Miranda and accused number 3. Once killed, they searched the house in vain for a safe. At some point, there was somebody calling from the gate on Peter Meyer's cell phone. Accused 3 answered the phone, informing the caller that Peter Meyer and his wife had a fight and suggested that he must come back later. This was corroborated by Stacco, who testified that when he was unable to gain a response from the intercom at the gate, he called Peter Meyer on his cell phone several times. He also confirmed that he later spoke on Peter Meyer's phone to a lady who informed him that the Meyers were having a fight and it was going on crazy, and that he should come back at a later stage. This is in contrast to the evidence of Miranda, that she answered the intercom and told the person that he should come back later because of the fight between the Meyers. They left the scene and on the way back disposed of the cable ties, wallets and cell phones. They kept the cash that was retrieved from Peter Meyer's wallet. Back at Kosana flat, accused 1 and Miranda went up to Miranda's flat to change clothing. Accused 3 went to accused 2 to report and realized she had blood on her pants, which was confirmed by Barnett in his testimony. The case was handed over to accused number 2, who handed a portion thereof to Barnett. Due to the failure to secure a large amount of cash, accused number 2 was unhappy with the outcome. I now deal with counts 14 to 20, which deals with theft, fraud, and defeating the ends of justice. Accused 3, although not charged with those offences, had been well aware of the plan to fake accused 1's death in order to obtain the proceeds of the life policy. According to accused 3, after the unsuccessful robbery of the Meyers, accused 1 volunteered to stage his death, thereby making available the proceeds of his life policy. This would fit in because previously he already made accused 2 the sole beneficiary of his discovery life policy. All these offences relate to the grand scheme involving accused 1 and 2, Miranda, LaRue, and Barnett, of faking accused 1's death and claiming the benefit of his life insurance policy from discovery, the sole beneficiary being accused number 2. In order to effectively and successfully achieve this goal, it was implicit and essential that the various secondary frauds also had to be committed. In my view, all the above mentioned individuals had a common purpose, not only in respect of the primary offence of defrauding discovery, but also in relation to the secondary offences of theft, fraud, and defeating the ends of justice. This grand scheme started off with the theft of the Villiers ID book, which according to him was already missing from its usual storage place at the time he fled accused number 1's house. As theft is a continuous of crime, every person who at some stage handled the actual document is also guilty of the offence of theft in respect thereof. According to LaRue, he and accused number 2 forged and or altered the ID document by replacing the Villiers photograph with that of accused number 1. This document was subsequently handed over to accused 1 and was eventually found in possession of accused 1 upon his arrest in 2016. It was never disputed that accused 1 was booked into the Herberg Hotel under the names of Jaak. According to de Villiers, a cell phone contract was furthermore purchased with the use of his stolen identity document. This evidence dealing with the cell phone is somewhat problematic, since there is some discrepancy as to when the phone was purchased. In order to successfully claim the Discovery Life policy, the accused had to ensure that all the required documentation relating to the staged death of accused 1 be completed by and submitted to the various different individuals and or state departments. The common purpose, therefore, included commission of all these secondary offences. Common sense dictates that once accused death was faked and the policy successfully paid out, accused 1 would require a new identity document in order to start a new life. To obtain a new false identity document was clearly an essential requirement in order to achieve this. It is evident from the evidence of Shane Chuckleworth that during the interview with accused 2, she blatantly lied in respect of various aspects, more specifically regarding the death of accused 1's wife, Michaela, in order not to arouse any suspicion regarding the accidental death of accused number 1. And I'll deal with count 21, which is the murder of Jared Jackson. This murder must be considered in the context of the offences set out in counts 14 to 20, as discussed above. Accused 3, although not charged with this murder, was well aware of the plan to fake the death of accused number 1. She confirmed that initially another person was considered to be the victim to die instead of accused number 1. That person refused to accompany accused 1, and because plans were already at an advanced stage, they were desperate to find a replacement victim. Jared was unfortunately at the wrong place at the wrong time, as and when he arrived at Kosana Flats. They immediately identified him as the replacement victim. Due to their previous encounters with him and giving him a lodging in a storeroom, he was an ideal victim because he did not have a permanent job and he suffered from a drug addiction and psychological problems. Furthermore, he was staying in a back room and living a subsistence life. He was brought under the impression that he was required to accompany 1 on a trip. Arrangements were made by accused 1 to pick him up at Kosana Flat later that afternoon to accompany him on this trip. According to accused 1's evidence, Jared requested a lift to an undisclosed destination, which is highly improbable. According to Candace Ellison, Jared told her that accused 1 had requested him to do him a favor and accompany him on a trip. He did not know where they would be going to, but could not refuse because accused 1 and 2 had helped them out before with accommodation, money, and by buying sweets from him. Part of the plan was that accused 1, LaRue, and Jared would be followed by Miranda and Barnett in a separate vehicle to help in executing the plan of faking the death in a burnt-out vehicle and to facilitate their return to Krugersdorp and the disappearance of accused number 1. According to LaRue, he and accused number 2 had prepared a concoction of juice and crush pills in order to make Jared drowsy and sluggish, preempting any effective resistance by him. The spiking of drinks is a common theme throughout. Michaela's coffee was spiked, Joshua's drinks was spiked, Jared's juice was also spiked. And Rhea also complained that one of the drinks was spiked in accused 2's flat, causing her to sleep the whole day. Amongst the accused and Miranda, the following versions were placed before court. Accused 1 provided 2 versions. The first version being at the bail proceedings in terms of Exhibit D, where his version was that he was driving along the highway when pulled over by an unmarked vehicle with blue lights. He was pepper sprayed and he ran away. The second version during the trial, and he only testified once, which was never put to any of the witnesses, was that he and Jared were driving towards Van der Bijl Park on the way to Clarence when he lost consciousness. He only regained his consciousness when he was entering Krugersdorp in the company of LaRue, Barnett and Miranda in the BMW vehicle. According to him, accused 2 had a vision, and that was a reason for sending them to follow him, That was the reasons he was in the BMW vehicle. The third version is of accused 2, who denied any acknowledgement or denied any knowledge regarding Jared, his disappearance, and anybody from the group following accused number 1 and Jared in the BMW vehicle. The fourth version is that as testified to by LaRue, Barnett and Miranda, except that according to her, accused knew nothing about it. This is further corroborated by accused 3, that it was a pre-planned, and accused 2 was part of the planning thereof. The evidence of Miranda, LaRue, and Barnett clearly shows accused 1's involvement. Accused 1's explanation in this regard is nonsensical and unsupported by any objective evidence or the probabilities. His version was a recent fabrication, as none of it was put to any of the state witnesses, and it was for the first time revealed after closing of the state's case during his testimony. It would have been an enormous risk, but also totally unthinkable to take along the person whose death was to be faked, him being unaware thereof, and not a voluntary participant thereto. Even more so, if that person must now disappear from the face of the earth for the rest of his life in order to successfully claim his life policy. Accused 2 is directly implicated by LaRue and Barnett as being directly involved in the planning of the murder and the mixing of the medication which was added to the juice, which was eventually given to the deceased in order to prevent any resistance during the actual murder. Accused 2's version that the deceased never visited the flat during the day of his murder is furthermore contradicted by the evidence of LaRue. The evidence of Candace is also very important and strengthens the evidence of LaRue and Barnett. She testified that the accused 2 told her many lies in respect of the disappearance of Jared. The killing of Jared also formed part of the common purpose of the group and was a crucial and essential factor in the grand scheme of claiming the 3.57 million benefit from accused 1's life policy. A conscious decision was taken by the group under the guidance of accused number 2 to change the group's modus operandi in respect of the murders so as not to create a pattern that could be linked to the earlier murders. This led to the strangulation of the victims as opposed to stabbings. This fits in with the body of Lategan not being disposed of in a similar fashion to that of Schofield and McAlpine by changing the location and not using her own branded vehicle. I deal now with counts 22 and 23, which deals with the murder and robbery of McGregor. Both LaRue and John testified to the fact that accused 3 was present during the murder. Miranda's evidence to the contrary stands to be rejected as false beyond reasonable doubt. Both witnesses testified that the 4 of them drove to the premises of the deceased, where John remained at the motor vehicle, whilst Miranda, LaRue, and accused 3 entered the deceased's house. According to LaRue, accused 3 entered the house with them and was present at all relevant times during the commission of the said offences. More particularly, she assisted in moving the body of the deceased to the bathroom, where it was put inside the bath, and she also assisted in searching through the house for money and all items to rob. Except for accused 3's presence and involvement in the commission of the offences, LaRue is corroborated by Miranda. Accused 3 contradicted Miranda regarding her not being present at the crime scene and participating in the commission of the said offences. Accused 2 should also be found guilty on the basis of common purpose. According to LaRue, the 600 rands that was stolen was later withdrawn from Miranda Stein's bank account and used for and on behalf of accused number 2. There is no evidence linking accused number 1 to the commission of these charges. I now deal with counts 24 to 30, which deals with the murders and robberies of the Schofield, McAlpine, and Lategan. These offences were all committed at 17 Kosana Flat, under more or less the same circumstances and employing the same modus operandi. The actual commission of these offences is not disputed by accused by accused 2. She, however, blankly denies any involvement in those offences. However, due to the concessions made by the state during closing arguments, and I've pointed this out earlier, accused number 3 should be acquitted also on counts 24 to counts 30. In respect of accused number 2, the evidence of LaRue, Barnett, and accused 3 clearly showed that accused 2 was the mastermind and motivating force behind the commission of these offences, in that she was a person who requested alternative methods of securing additional income / money. Furthermore, accused 2 was at all relevant times part of the planning of these offences, and she was a subsequent beneficiary of the proceeds of these crimes. Typically, how the mastermind of an enterprise would act: give instructions, distance yourself from the crimes, and receive proceeds from the enterprise or from the crimes. Accused 2 would therefore also be guilty on the basis of common purpose. In addition, both LaRue and Barnett testified that accused 3 was at all relevant times not only aware, but actually being part of the planning and execution of these offences. Accused 3 was tasked to wait in the adjoining room whilst playing loud music to mask any possible suspicious sounds. Once the victim was accosted and tied up, and the PIN numbers coerced from the victims, accused 3 would be handed the bank cards together with the relevant PIN numbers in order to confirm the correctness of the PIN numbers. Once the correctness of the PIN numbers were confirmed at an ATM, accused 3 would telephonically inform either LaRue or Marinda thereof, and the latter would then proceed with the killing of the victim. Accused 3 would then return to accused 2's flat, where the cards and pins would be left with accused number 2. Accused 3 has now confirmed this evidence. In the case of Johanna Lateghan, accused 3 also withdrew the money at an ATM herself and returned it to accused number 2 at her flat. As with all the previous appointment murders, due to an altercation between LaRue and Marinda, LaRue did not assist with the removal of the body from the scene, but accused 3 assisted in having the body removed from the flat and disposing of it next to Tarleton. It was contended by the state that that accused 1 would also be guilty on the basis that he had at all relevant times were not only aware of the commission of the offences, but he also formed a common purpose with the actual perpetrators and directly benefited from the proceeds of the crime. Alternatively, accused 1 was guilty on the basis of being a necessity after the fact. Whilst in hiding, he was putting pressure on the enterprise to give more money, according to the evidence of Marinda, well knowing it was the proceeds of crime. Marinda was in direct communication with him by means of the tablet she gave him, and also received feedback from the go-between LaRue. The state, however, had to concede that there was simply no evidence supporting this, since LaRue did not back the version given by Marinda when he testified. This much was also confirmed by accused number 3. Accused 1 had also testified that he had instructed LaRue to his cell. Let me repeat this. Accused 1 had also testified that he had instructed LaRue to sell his belongings, and that the proceeds of his belongings were given to him. I've already pointed out that the state considered that accused number 1 should be acquitted on the said charges. I now deal with counts 31 and 32, which is the illegal possession of firearms and ammunition. The state relied on the legal principle of joint possession in respect of the firearms and ammunition. In State v. Makubela and another 2017 Volume 2 SACR 665 judgment of the Constitutional Court, the approach regarding joint possession was reiterated with reference to State v. Kwanda 2013 Volume 1 SACR 137 SCA at para 6, that an inference of joint possession is justified where the state has established facts from which it can properly be inferred that the group had the intention, animus, to exercise possession of the guns through the actual detentor, and the actual detentors had the intention to hold the guns on behalf of the group. The evidence before the court is that accused 1 obtained the firearms, save for 1, from a lady and brought it to Kosana Flats, where it was handed over to the group. He, as well as the other members of the enterprise, each selected their preferred firearm. LaRue was tasked to conceal these firearms on behalf of the group, and did so by devising a false compartment. at 17 Kosana flats, as well as hiding some of the firearms behind a wall in close proximity of the flats. The accused had the required intention to exercise control of the firearms through the actual detentor, notwithstanding their denial of any knowledge in this regard, save for accused number 3, who admitted knowledge thereof. All the members of the group were aware of the firearms and the location of the hiding place. All the members of the group knew that since the Meyer murders, excluding the murder of Jackson, firearms were used to initially hold up the victims, immobilize, rob, and then kill them. Firearms were indispensable to the group for the successful execution of the robberies in accordance with their modus operandi. Charles Maynard testified that he was involved at a certain stage at Kosana Flats. Oh no, let me repeat this. Charles Maynard testified that he was invited at a certain stage to 17 Kosana Flat, where the firearms were packed out and exhibited on the floor. He was specifically questioned as to the capabilities and utilization possibilities of the various firearms. Those present, including accused number 1 and accused number 2, each identified and indicated their favorite firearm. Accused 3 also entered the flat, and at some stage, whilst the firearms were being exhibited on the floor. According to accused number 3, Miranda even gave her a favorite firearm named Charlie. Accused 3 was furthermore present when Miranda used a firearm during the murder of McGregor, and she was also present where Miranda brandished a firearm during the murders of Schofield, McAlpine, and Lategan. It is clear, therefore, that the accused all had the intention to jointly possess all the firearms, even though they may not have been in physical possession thereof. The inference is inescapable that the intention was that these firearms were to be possessed for and on behalf of the members of the inner circle for purposes of using same in the execution of the inner circle's criminal activities. Similarly, it's clear that the firearms were possessed by LaRue, Stein, and Miranda for and on or behalf of the group in the criminal enterprise. The same argument applies in respect of the unlawful possession of ammunition. Applied to the facts of this case, the inference of an intention to jointly control and possess the firearms and ammunition is unavoidable. I'm not dealing with the evidence of Miranda Stein. Miranda previously pleaded guilty in terms of a plea and sentence agreement and was called by accused 2 to testify on her behalf. It is clear from her evidence that although she had admitted her involvement in all the counts that she was convicted and sentenced of, that she had attempted to exonerate accused number 2 and 3. She was contradicted by her own daughter, accused number 3. Her evidence is accepted to the extent that it incriminates herself and accused number 1. However, insofar as she stated that accused 2 and accused 3 were blissfully unaware of and totally uninvolved in the criminal activities involving the members of the inner circle, that evidence is rejected as false beyond reasonable doubt, insofar as it is contradicted by other evidence, especially that of LaRue, Barnett, and accused number 3. There is ample evidence by various witnesses that accused 2 was at all relevant times the driving force and mastermind behind the criminal activities of the enterprise. This is borne out by the probabilities to the extent that most, if not all of it, not all of the planning took place in one Kosana flat in the presence of accused number 2. Furthermore, that after each such criminal endeavor, a feedback meeting would be conducted, again in one Kosana flat, in the presence of accused number 2. The final nail in the coffin was the evidence of accused number 3, implicating herself as well as accused number 2. Furthermore, in terms of section 2.1f of POCA, all that is required to prove is that accused 2 was a manager, was that she reasonably ought to have foreseen what was happening. The evidence is overwhelming that she must have known and in fact was the instigator and the only one issuing the instructions to commit the crimes. Miranda is the type of person that will not shy away from lying under oath to falsely protect accused number 2 and accused number 3. In the light of the overwhelming evidence against accused number 2 regarding her involvement at all stages in the criminal activities of the inner circle, Miranda's attempts to exonerate her of any knowledge of any involvement in any criminal activities is blatantly false. Due to the evidence of accused number 3, there is sufficient cogent factual basis to conclude that Miranda was lying in an attempt to falsely exonerate both accused 2 and 3. This is further strengthened by the admission of accused 3 that there was a conscientious attempt by accused 2, Marinda and herself, that Marinda would plead guilty, taking all the blame and exonerating accused number 2 and 3 entirely. Unfortunately, this plan backfired, and it was clear, even in her evidence, that she was shying away from implicating accused number 2 and 3 in any criminal activity. Both LaRue, Steyn, and John Barnett previously pleaded guilty and were sentenced in terms of the formal plea agreements in terms of Section 105 of the CPA Act. Section 204 of the CPA is not applicable to them. It was evident through their evidence that they took full responsibility for and testified in great detail regarding their own involvement in the criminal activities. Their evidence is also objectively corroborated on many aspects, thereby giving support to the truthfulness thereof. It also has a ring of truth to it and fits perfectly into the bigger picture and is supported by the probabilities. After accused 3's testimony, which also corroborates their version, there's no reason why their evidence should not be accepted. LaRue was an excellent witness. He testified over several days, was aggressively cross-examined. Notwithstanding that, he stuck to his version and portrayed a good impression and made a good impression on me. His demeanor was one of somebody talking the truth. Not only is his evidence corroborated by the objective facts, but Barnett as well as accused 3 corroborated his evidence in material respects. The evidence of Barnett is also accepted since it was corroborated by various other witnesses and the objective facts. He was part of the planning by the group, and his participation was that of a foot soldier of the enterprise. There was no indication in their evidence that they, at any stage, attempted to implicate any of the accused unnecessarily, despite the fact that they could easily have done so as a result of their intimate knowledge of the enterprise's criminal activities. There is furthermore ample corroboration for their evidence, confirming the truthfulness and reliability of them. Accused 1 was an extremely poor witness. He made no good impression on me when he testified. The state's case is overwhelming in the light of no version being placed on record by accused number 1 to the witnesses to respond to, except for a bare denial. His latest version only became clear during his testimony and was never put to any of the witnesses for them to comment on. Speculative suggestions were put to the witnesses, such as that he was acting under hypnosis, acting under a supernatural spell, a possible drop in his blood sugar, and or tampering with his insulin medication. None of these speculative propositions were repeated under oath by accused number 1. It is right that an accused is obliged to put his version to the witnesses for them to comment thereon. In President of the Republic of South Africa and others versus South African Rugby Football Union and others, 2000, Volume 1, SA 1 CC, the following stated by the CC under paragraphs 61 and 63, and I quote, "The institution of cross-examination not only constitutes a right, it also imposes certain obligations. As a general rule, it is essential when it is intended to suggest that a witness is not speaking the truth on a particular point, to direct the witness's attention to the fact by questions put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity, while still in the witness box, of giving an explanation open to the witness and of defending his or her character. If a point in dispute is left unchallenged in cross-examination, the party calling the witness is entitled to assume that the unchallenged witness's testimony is accepted as correct. This rule was enunciated by the House of Lords in Brown v. Dunn and has been adopted and consistently followed by our courts. The precise nature of the imputation should be made clear to the witness so that it can be met and destroyed, particularly where the imputation relies upon inferences to be drawn from other evidence in the proceedings. It should be made clear not only that the evidence is to be challenged, but also how it is to be challenged. This is so because the witness must be given an opportunity to deny the challenge, to call corroborative evidence, to qualify the evidence given by the witness or others, and to explain contradictions on which reliance is to be placed. In State v. Busak, 2001, Volume 1, SACR 1, also a decision of the Constitutional Court at paragraphs 26 to 27, the court remarked as follows, and I quote, The essay has also concluded that, having regard to the evidence which had been given and the way in which the trial has been conducted, in particular, there had been no challenge to the authenticity of the letter. It should not have been expected of the state to call a handwriting expert to prove Dr. Busak's signature. It said that a criminal trial is not a game of catch as catch can, nor should it be turned into a forensic ambush, and referred to with approval to the comments of this court in President of the Republic of South Africa and others versus South African Rugby Football Union and others that, as a general rule, it is essential when it is intended to suggest that a witness is not speaking the truth on a particular point to direct the witness's attention to the fact by questions put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity, while still in the witness box, of giving an explanation open to the witness and of defending his or her character. This rule, which is part of the practice of our courts, is followed to ensure that trials are conducted fairly, that witnesses have the opportunity to answer challenges to their evidence, and that parties to the suit know that it may be necessary to call corroborating or other evidence relating to the challenge that has been raised. The essay held that this rule applies to the challenging of all evidence adduced by the other party, whether on the basis of hearsay, inadmissibility, lack of proof of authenticity or accuracy, close quotation. The failure to put material evidence aspects of the first accused version to the prosecution's witnesses and to cross-examine those witnesses on those aspects raises some doubt about that version. He has raised 3 versions, none of which can be true. Even if one of the versions was true, which one is to be accepted? It is clear that he made up his versions as and when the matter unfolded before him. Accused one's version in respect of the murder of Jared and the charges relating to and flowing from the main fraud charge set out in count 19 is outrageous and totally unsupported by any independent or objective evidence. Firstly, he did not repeat his so-called version made during his bail application when he was pulled over by the police officials and he managed to escape. His explanation as to his contradictory bail version placed before the lower court in his bail application, to it that his defense counsel was to blame, is totally unacceptable and ridiculous and is rejected as false. In court, he came up with a new version and contradicting let me repeat. In court, he came with a new and contradicting version that Jared accompanied him on a trip, that he lost consciousness on the way, and he hid away to protect his family from harassment by the Satanic Church. The rest of his version amounts to a bare denial. None of these versions are borne out by the probabilities and is contradicted by direct evidence from various witnesses, namely LaRue, Miranda, Barnett, and accused number 3. There are so many improbabilities in respect of accused one's version. It's highly improbable that he would have given Jared a lift with no predetermined destination in mind. It's highly improbable that a lawyer in a formal bail affidavit would have written down anything other than what was told to him by accused number 1. It is highly improbable that he would have driven to Van der Bijl Park and then out of the blue lost consciousness, only to regain consciousness upon the return to Krugersdorp. It is highly improbable that he would be willing to book himself into the Herberg Hotel under a false name on the spur of the moment in order to protect his parents and brother from the Satanic Church. Being a well-educated adult, it is highly improbable that he would not have known about or was part of the creation of a false identity for himself, even more so if he was found in possession of such a false identity document. Being an expert in life policies of discovery, it is highly improbable that he would not have known exactly what is required in order to get a life policy to pay out to a beneficiary. He knew exactly what paperwork was required. It is highly improbable that he would have agreed to fake his death for any other reason than obtaining the benefit, the payment of the insured amount in terms of the policy. It is highly improbable that he would, on the spur of the moment, agree with Miranda to go into hiding and fake his death. Such a radical decision would only be taken after thorough planning and considering all the pros and cons associated therewith. In respect of all the other charges, accused 1's version is a blank denial. However, the evidence against accused 1 is simply overwhelming. There is direct evidence by Marinda, as well as accused 3, implicating him in the murders of Reg Ben Dixon, Michaela, the Meyer couple, and Jared, as well as implicating him directly in respect of the conspiracy to murder Joshua Groenewald. In respect of his involvement in counts 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 13, he is implicated by the evidence of LaRue, Stein, Barnett, as far as counts 11 to 13 by Marinda and accused 3. In respect of count 14, the theft of the ID document, it should be considered that it was not disputed that the fraudulent, let me repeat this. In respect of counts 14, the theft of the ID documents, it was not disputed that the fraudulent identification document was found in his possession. And as theft is a continuous offense, there is sufficient evidence for a conviction. Furthermore, it formed part of an elaborate plan to fake his death and to give himself a new identity. In respect of the fraud charges, counts 15 to 19, as well as counts 20 and 21, all forms part of the overarching plan to fake his death and successfully secure a payment in terms of the life policy. The fraud charges forms part and parcel of the faking of his death. Common sense dictates that nobody would fake his own death, if there's not something in it for himself. Accused 3 testified that according to the plan, accused 1 would have received a substantial amount of his life policy in order for him to start a new life. The debt could not be faked unsuccessfully without the subsequent frauds being committed in order to officially be declared dead on the population register. To achieve that, all the auxiliary frauds had to be committed. Accused 1 therefore shared a common purpose with the actual perpetrators of the frauds. Accused 1, on the basis of common purpose, is therefore guilty in respect of those charges. Without him being reflected as deceased on the population register at Home Affairs, no payment would have been made in terms of the life policy. That is also the reason why accused 1 had to remain in hiding under a false name and presumed dead until such time as the policy had paid out. As pointed out earlier, the state had considered that accused 1 I've already dealt with the concessions made by the state in relation to the other charges where accused 1 should be found not guilty. And just on that, there obviously was simply no evidence which would have supported the state's case. The evidence that the state had relied upon was that of Marinda about what she was told, and that was rejected. He should therefore be acquitted from the subsequent murders that took place after the murder of Jared Jackson. It is my finding that the state has proven that accused 1 associated himself with the enterprise over a substantial period. There is direct evidence showing that he was part of the inner circle of Electus Pedaeus, that he actively participated in various murders except what has now been dubbed the appointment murders on behalf of the enterprise, and or on the instruction of the leader, stroke manager of the enterprise, accused number 2, which participation in the predicate offences formed part of the pattern of racketeering. He was also the main financial supporter of accused number 2, the manager of the enterprise. In view of the above-mentioned predicate offences, his ongoing association with the enterprise, he therefore clearly contravened the provisions of Section 2(1)(e) of POCA. It's also clear from the evidence that the enterprise had a specific and identifiable name, as pointed out earlier, Electus Pedaeus. All the members of the inner circle, including accused number 1, had an identifying symbol, a tattoo depicting the name of Electus Pedaeus. Accused 2 denied that she was involved in any of the murders that she was accused of. She denied that she had a ministry and was its manager. She denied that she was part of the planning and or report back when the murders had taken place. She had read about all the murders that had taken place in the newspapers. She had denied that she was a 42nd generational witch, came out of the Satanic Church, and knew about the existence of an orphanage and had supernatural powers. She aimed to create the impression that she was an innocent, law-abiding citizen who had, for no demonstrable reason, been falsely implicated in a series of very serious murders and other offences by various state witnesses, and even a co-accused. She was unable to provide a cogent reason why anybody would falsely implicate her in the commission of criminal offences or lie about the existence of a ministry or religious grouping called Electus Pedaeus. Her evidence amounts to a bare denial of any knowledge of or involvement in any crime. However, it is clear that accused number 2 had lied to and manipulated all the people that she had contact with, starting with Ria, including other members of, firstly, the Overcomers Through Christ, and secondly, the ministry surrounding her, Electus Pedaeus, and lastly, her co-accused. On the available evidence before me, it is indisputable that accused 2 is a pathological liar and a highly skilled manipulator. She did not create a good impression on me as a witness at all. She was argumentative, failed to answer questions directly, and denied any knowledge of any wrongdoing. She was an evasive witness who had abused the generosity of caring individuals who had believed that they were making a difference in their fight against Satanism. Of course, I accept that Satanism is not an offense in this country, but she had abused people who had believed that it was an ill in the society. It has been shown beyond a reasonable doubt that accused 2 lied to the group, as well as other witnesses, about the following aspects. In her evidence, she vehemently denied that she told the group or the witnesses about this. Her need for constant spiritual protection, her so-called supernatural powers, donations required for the orphanage and or sending people overseas, and related financial issues, her academic qualifications and degrees, her various professions, the fake boyfriend-girlfriends she created for LaRue, Candace Ridgewick, and Miranda, and her medical condition. Her bare denial of any involvement in the occult does not make any sense in the light of the evidence of all those involved in looking after her and attending the numerous high days that were specifically focused on protecting her from satanic attacks. The whole reason for Ria's involvement in accused 2's life was because of the fact that accused 2 proclaimed to have been involved in the occult, and that she therefore required protection from satanic spiritual attacks. From the evidence as a whole, the contrary is quite clear. This was a ministry to promote KYE in opposition to KYS. According to the witnesses, it was a ministry created to look after the orphans of the so-called satanic church, as well as for the protection of people leaving the satanic church and to be sent overseas for safety reasons. Ex post facto, it transpired that this was all part of accused number 2's strategy to manipulate and mislead the group in order to generate money for her medical expenses and her personal lifestyle. This was a religious scam like so many that we see nowadays in our country. In order to give credence to the scam, the role she portrayed, it had to be played as convincing and authentic as possible. For this reason, she claimed to have physical boundaries which may not be crossed, required constant protection from the attacks of the satanic church, claimed to be vulnerable and open to attacks on so-called high days of the occult, possessed supernatural powers such as levitation, astral projection, mind reading, be able to walk on water, to see in the spiritual realm, and to be able to identify demons in others. To keep up this appearance, huge amounts of money was required, and she convinced many people to donate to the ministry. The enterprise can only be compared to a religious cult, where the members of the cult are so misled and manipulated by the lies of their cult leader, and that these lies later became truth to them. Testimonies of many witnesses who initially believed all the deception and lies were placed before this court. They later realized the deception thereof. To name but a few of these people was Ria Groenewald, Candace Ridgewick, LaRue, Barnard, de Villiers, Rana van Lochenberg, Schall, and Jonita Trutte. Their insight to break away ensured their ultimate survival. Ultimately, accused 3 also saw the light. Accused 2 had created the impression of a victim of the Satanic Church in order to generate sympathy and support from the group in order to unify them through her manipulation and indoctrination behind her and her cause. It is clear that she was a master of deception and manipulation. Her initial motivation was to get members of the group to execute a vendetta of revenge against Ria. This was done in a sadistic way by hurting people close to Ria and her ministry. It started off with a relatively innocent incident of threats, not causing much physical harm, but it gradually escalated in severity, eventually culminating in several brutal crimes of passion. Her manipulation of and control over members of the group was of such an extreme nature and so convincing that they would do anything for her, including committing murder. By quoting out of the context excerpts from the Old Testament of the Bible to justify the killing of innocent people, the deceit was so masterfully done that even accused number 3 believed that she was devoted to this ministry on a similar basis as Samuel from the Old Testament. The killings were justified on the basis of the wars waged by King David against his enemies, killing everybody and everything, including women, children, and livestock. Accused 2 was able to even convince professionally qualified adults to follow her blindly. She only has a standard 7. Even now, her control over Miranda is such that Miranda is prepared to take the blame for everything in order to protect and exonerate accused number 2. One person, and only one person alone, remains a single common denominator in respect of all the charges set out in the indictment, and that person alone is accused number 2. The commission of each and every predicate offence can be traced back in one way or the other to one Kosana Flats, and accused 2, and is therefore inextricably connected to accused number 2. She is the center around which everything evolved, and is the mastermind of the enterprise and all these crimes. If she is taken out of the equation, there would have existed no motive or reason to commit any of the heinous crimes. Despite accused 2's vehement denial of the existence of any ministry involving herself, the evidence is quite clear that there was this grouping with their distinct tattoos and who associated themselves with accused number 2 and functioned in and operated from her flat at number 1 Kosana Flat and under her guidance and instructions. Not only was accused number 2 at all relevant times aware of the actions of the rest of the group, but she also initiated and directed the actions of the members of the group. Although this group by times also included other members, the inner circle of the electus Pedaeus was constituted by accused number 2, Miranda, accused number 1, LaRue, accused number 3, and Barnett. Huge amounts of money was paid into the account or handed over to accused number 2. The donors were co-accused and state witnesses. Accused 2 was also made the beneficiary in almost all the policies taken out by the group, and Miranda even made her the sole heir of her estate. Accused 2 also entered into 17 Kosana Flats and kicked the body of Mark Alpine, clearly showing common purpose with the actual perpetrators. According to accused number 3, she was the center of everything, and nothing would happen without accused 2's authorization thereof. That is why she was involved in the planning, allocation of specific tasks, and receiving feedbacks on the success or otherwise of the missions. This also fits in to an organized crime scheme where the mastermind is distancing himself or herself from the crimes being committed by the enterprise through the runners or foot soldiers acting as pawns. The mastermind, being the puppeteer, pulling the strings and giving instructions, is also the person receiving the benefit, being the proceeds of crime, which have also been committed by the foot soldiers. The following improbabilities exist in accused number 2's version. It is highly improbable that she would have been a victim of a conspiracy to falsely implicate her in these offences. It is highly improbable that she never mentioned so-called boundaries placed on her by the Satanic Church when several witnesses testified to this effect. Accused 1 and 3 confirmed the existence of these boundaries as testified to by most of the state witnesses. It is highly improbable that the so-called orphanage of people to be sent overseas was a figment of the witnesses' imaginations, and that she never mentioned it, taking into account the excessively large amounts of money being paid over to her by various individuals. No acceptable reasons were advanced by either Marinda or accused number 2 for the receipt of these large amounts of money or the nomination as beneficiary to the wills and policies. The only reasonable inference is that accused number 2 was made the beneficiary and received the money in her capacity as a leader of the enterprise. It is highly improbable that the so-called high days were just social gatherings and had nothing to do with the occult or the ministry of electus per deus. According to the various witnesses, most of the plannings and report back, as stated earlier, happened at 1 Kosana flat. Accused number 3 and LaRue stayed in the flat at the time of the commission of the offences. This is also where LaRue overheard exactly what happened during the 2012 murders. The probabilities favour LaRue's evidence that he heard of the murders in accused 2's flat, especially if we take into account the evidence of Candace, who is an outsider, about what happened to the deceased Jared at accused 2's flat. It is highly improbable that everybody closely linked to her in her group, electus per deus, committed series of crimes which benefited her while she was unaware of any criminal activities and or planning and feedback sessions that took place in her flat. This is also corroborated by the direct evidence of accused 3. If accused 2 is taken out of the equation, then no reason remains or exists for the commissioning of any of the 2012 murders, according to state witnesses. The only person who had a clear motive to take revenge on Ria was accused number 2, after the rift between Ria and accused number 2. All the victims were closely aligned with Ria. Even accused 1's disappearance is directly linked to accused 2, her being the sole beneficiary of his life policy. In accused 2's absence, accused 1 would also not have paid over large sums of money to accused number 2. It is clear that accused 2 was the mastermind of all the activities and everything revolved around her. Nothing was done without her blessing. She called all the shots, and this was confirmed by almost all of the witnesses. Even accused 1 was eating out of the hands of accused number 2. Due to her manipulative nature and persuasive powers, she was able to easily convince the other members of the enterprise to believe everything she told them and to execute her instructions and wishes without doubt and questioning. This is clearly exhibited by Marinda, who firstly bequeathed her entire estate to an outsider and not her own flesh and blood and relatives, and secondly, by giving accused number 2 power of attorney relating to all her affairs. In the words of LaRue, accused 1 was like a lapdog to accused number 2, which is confirmed by the payment of more than 1 million rands, or more than 2 million rands to accused number 2, as he paid over his money without questioning at her request. Accused 2's version before this court. Yes. I'll not deal with the version of accused number 3. Accused 3 was born on the 21st of October 1997. She turned 14 on the 21st of October 2011. At the time, the first offences were committed, as from June 2012. She was already over the age of 14, being 14 years and 7 months old. She therefore had the required criminal capacity during 2012, since she was already over the age of 14 years. She turned 18 on 21st October 2015. She was only arrested on 26th of June 2016, and was therefore already over the age of 18 when she was brought before court. Accused 3 turned 21 on the 21st of October 2018. It is clear, therefore, that in terms of Section 4 of the Child Justice Act 75 of 2008, that the provisions of the Act, and therefore also Section 7 and 11 thereof, are not applicable to her. In respect of count 1, there is evidence of 2 or more predicate offences being committed by accused 3 as part of a pattern of racketeering. This brings her into the ambit of Section 2(1)(e) of POCA. The evidence of LaRue, Steyn, and de Villiers implicates her in the commission of the offences in counts 3, 4, and 5. The evidence of Marinda, her mother, who attempted to exonerate her of any involvement has already been rejected as false in the light of accused 3's own admissions. As far as counts 6 and 7 are concerned, accused 3, on her own version, admitted to be part of the planning, scouting, and the first unsuccessful attempt. On the basis of common purpose, she is clearly guilty in respect of both murders. As far as count 8 is concerned, de Villiers implicated her to the extent that she was present at the scene and also stabbed the deceased. From a reading of the indictment, it is clear that she has never been excluded from count 8. She also pleaded to the count, and evidence to the effect of her involvement has been led. Count 8 is therefore applicable to her, and the mere failure to refer to her involvement in the preamble does not absolve her from being convicted on this count. The evidence tendered during the trial, including her own version, is sufficient to sustain a conviction. In respect of count 9, the evidence of LaRue implicates her in being present with Miranda at the scene when Michaela was stabbed to death. Accused 3 on her own version stabbed the deceased once. On counts 10 to 13, she has on her own admitted having committed those offences. This is supported by the evidence of the state. On counts 22 to 30, she is guilty on the basis of common purpose, as well as her evidence that she was part of the perpetrators and assisted in the commissioning of all the crimes. On counts 31 and 32, accused 3 had been aware that firearms were used during the commission of the murders to subdue the victims prior to strangling them. In respect of the McGregor murder, a firearm had been used and two shots were fired. She was furthermore present when the firearms were unpacked for Charles Maynard to look at and advise the members of the group on the capabilities and firing power thereof. She is guilty on the basis of joint possession on behalf of the enterprise. The evidence against accused number 3 reveals that she had the Electus Bay per Deus statue on her. She stayed at Cosano number 1 together with the mastermind accused number 2. She was aware of the feedback meetings and the planning sessions that took place regarding the criminal activities of the group. There was direct evidence that she was present during some of the feedback meetings that were held at one Cosana flats. There was direct evidence that she committed some of the crimes starting as early as 2012, which includes her own evidence. On the evidence against her, it is clear that she had been involved with the criminal activity of the inner circle of Electus Badeus. It started with her scouting the scene at Natasha flat and changing batteries on the tracking device on Ria's flat, and included the various incidents relating to the explosions and injury to property at 11 Kelly Street and the Lighthouse Church incident. It furthermore encompassed the murders and related robberies of Ben Dixon and those subsequent thereto, and included the joint possession of firearms and ammunition. Although accused 3 had admitted in great detail her involvement as part of the group in all the crimes, she raised the defense of compulsion, in brackets necessity. She admitted in her testimony that she was part of the enterprise stroke group, contributed to the planning by giving inputs, and participated in committing the offences charged with and or having common purpose with the actual perpetrators. Her only reason given for her participation in those crimes is that she had been manipulated and or brainwashed by accused number 2 and or her mother into believing that it was the will of God to commit those offences. This defense cannot hold any water and is rejected. She might have been still young and naive, but the killings of innocent people can never be condoned or justified under these circumstances. It is clear that accused 3 at all relevant times acted with the full knowledge of unlawfulness of her actions and that of her co-accused. It must also be borne in mind that she is highly intelligent. The timing of accused 3's revelation of her defense of necessity is extremely suspicious and disingenuous. In the context of the relevant facts, it appears to be a tactical decision to leave it till the last end, when it was improbable and impossible to test the veracity of allegations of duress against not only the evidence of the state witnesses, but also against the evidence of her co-accused. the mere presence of fear is not sufficient. The nature and extent of the fear or duress must be such that it is reasonably expected that somebody in that situation would have acted as she did before the defense would have succeeded. There is a difference in approach regarding the defense of necessity pre- and post-Constitution. Pre-Constitution, the locus classicus case is that of State v. Goliath, 1972, Volume 3, SA 1A, where on a reservation of two questions of law, it was found by the majority that compulsion may constitute a complete defense in the law that justify the acts of an accused, depending on the specific circumstances of each case. In the matter of State v. Bailey, 1982, Volume 3, SA 772A, the accused was a 17-year-old gang member who assisted a mature co-accused to kill another prisoner. The accused claimed he acted under duress. The trial court convicted the accused of culpable homicide, but on appeal to the appellate division, the conviction was changed to one of murder. In considering the issue of unlawfulness, the court approached the matter as follows, and I quote: Weliswaar is die kwestie van wederregtelikheidsbewussyn nie uitdruklik aan enige ondervraging van die respondent geopper nie, maar dit lyk uiters onwaarskynlik dat die respondent nie besef het dat hy verkeerd doen deur te help om die oorledene om die lewe te bring. Weliswaar getuig hy van hoe bang hy was as gevolg van nommer 1 se dreigement om hom dood te maak as hy nie meer help nie. Maar tog het sy vrees hom nie verhinder om nog 'n ruk te slaap voordat die aanval op die oorledene gedoen is nie. Die verhoorhof het terug bevind dat die respondent slegs tot 'n uitermate wel onder dwang van beskuldigde nommer 1 opgetree het en nie dat hy roekeloos vreesbevange was nie. Die respondent mag wel onder dwang en bona fide vrees vir sy lewe gehandel het, maar dit moet aanvaar word dat hy die wederregtelikheids van sy aanval op die oorledene besef het. Daar is geen kwessie dat hy werklik kon geglo het dat omdat sy lewe in gevaar was, soos hy gedink het, die aanval regmatig was nie. Dit volg dat hy by beantwoording van die rechtsvraag dit aanvaar moet word dat die respondent ondanks sy vrees wederregtelikheidsbewussyn gehad het. The threat of harm, close quotation, the threat of harm may become relevant during the sentencing stage, as was pointed out in State v. Bailey, where the following was stated, and I quote: Dit volg dat aangezien die respondent die oorledene help dood het met opset gepaard met wederregtelikheidsbewussyn, hy aan moord skuldig bevind moes gewees het, egter met 'n bevinding van versagtende omstandighede. Post-Constitution, the courts have now adopted a more strict approach when considering the taking of another person's life in the context of compulsion, as is evident in the matter of State v. Mandela, 2001, Volume 1, SACR 156C, at pages 166A to 167D, and I quote: As Professor Birchall in the South African Criminal Law and Procedure Volume 1 writes, the defense of necessity arises when confronted with the choice between suffering some evil and breaking the letter of the law. In order to avoid it, the accused chooses the latter alternative. The term necessity is used here to cover his dilemma's situation when it is brought about by the force of surrounding circumstances or by human agency, duress and coercion, since the law is the same in both instances. Van der West lezen een noodstand van rechtvaardigingsgrond in die strafrecht said the following: submits that in principle there can be no distinction at all between necessity and compulsion, a view which is supported by the Wet and Swanepoel strafrecht at pages 81 to 92. The most difficult aspect of this defense concerns the taking of life. In State v. Goliath, the appellate division held that compulsion could, depending on the circumstances of the particular case, constitute a complete defense to a charge of murder. As justification for this conclusion, in the context of South Africa, the current climate of violence and blatant disregard for human life would tend to provide a reason to curb the defense when life is involved. But this factor must be counterbalanced against the right to life enshrined in Section 1 of the Republic of the South African Constitution. A person who is faced with the most agonizing of choice of safeguarding his own right to life at the expense of another right to life may be regarded as not having the requisite mens rea, although he may have culpa when he fails an objective test. However, given the exquisite balance between the conflict between the two rights bearers of the most precious of rights, a court can only find necessity to be a defense such that the accused then lacks the requisite culpability in circumstances where the debt of danger cannot be averted, save by acts of heroism, which extended beyond the capacity that should and can be demanded of the reasonable person. There was no immediacy of life-threatening compulsion as there was in the state of Goliath, where a court to accept so low a standard in finding the existence of such a defense, it would be guilty of demanding very little from members of our society, which is now a constitutional community, based on fundamental principles, including those of freedom, dignity, Ubuntu, and respect for life. Were the defense of necessity to be extended as far as Ms. Wismer urges, it would represent a lowering of regard for life and undermining of the very fabric of the attempt to build a constitutional community where each and every person is deserving of equal concern and respect, and which community grows sourced in the principle of Ubuntu, close quotation. In Kasu, accused 3, at all relevant times, fully well knew that she was acting unlawfully. This conclusion supported by her own evidence that on her first attempt to kill Ben Dixon, she became nauseous and did not want to continue with the murder. Also in respect of Michaela's murder, she only stabbed her once and then lied to her mother about the knife being blunt. In State v. MD and another, the requirements for the reliance of this defense has been set out. And this judgment, this matter is under 2017 Volume 1 SACR 268 ECB at paragraphs 53 to 57. I don't have to quote this. Accused 3 does not meet the requirements for a successful reliance on the defense of necessity in the form of compulsion and duress. The threat was neither imminent nor had it commenced. The threat, if any, was caused by accused 3's own fault, as she voluntarily associated with the group. Her participation in the killings was not necessary for her to avert the danger. She could easily have distanced herself therefrom. Objectively speaking, the averting of the danger by threatening and killing innocent people was not reasonable under the circumstances. How much time do we have?
Well, it's almost 4 o'clock.
Almost 4 o'clock. I think I've probably got another, it'll probably take me another 15 minutes. Do we have time?
They gave an indication to me that 4 o'clock is the latest they can do. It's almost there now. Already half an hour over the
limit.
yeah.
Yeah, I think it's probably going to take me another 10 minutes to read it out. But
we're in the 4 seconds.
No, I think can somebody just make arrangements another, say, 10 minutes or so?
As it would be.
Or is that possible? We can adjourn until tomorrow.
I think minimum is possible. So if
it's possible.
Just carry on. Yeah.
Yes. The threat of harm therefore did not meet the requirements and therefore falls short of the high standards required for relying on this defense. The biggest distinguishing factor in respect of the few cases where the defense of necessity succeeded are the following. That accused 3 was not involved in a once-off single incident. There was no imminent threat, but only a vague general threat that if she does not toe the line, that something will happen to her, and later that the same fate as Michaela will befall her. Her participation in criminal activities spanned a period of approximately 4 years, from 2012 to 2016. There was a lull of approximately 2.5 years between the conspiracy to kill Joshua and the next murder being that of the Mayers. She's highly intelligent, which is proven by the 7 distinctions she obtained in grade 12. She was also in a very good school, where there are school psychologists available for counseling and or the opportunity to approach the headmaster for assistance and or guidance. Once she turned 18, and on 21st October 2015, She had ample opportunity as an adult to distance herself from the group and or approach the law enforcement authorities to assist and or protect her. It was known to her that despite her brother and Barnard's confessions to the law enforcement authorities, they were effectively protected, detained safely, and dealt with fairly. It is evident that the influence of accused 2 no longer had any effect on them, and nothing sinister happened to them. Even upon her arrest, the police invited her to cooperate with them and tell the truth. This invitation was subsequently extended to her on various occasions. She resisted these invitations and opportunities to obtain the necessary help and protection. She even resisted it when, according to her, she was tortured by the police. An open and often repeated invitation to her to enter into plea and sentence agreement with the state was also rejected. She pleaded not guilty and elected not to proffer any plea explanation. During the duration of the trial, she persisted in a blank denial of any acknowledgement or involvement in any criminal activities. It was also a strategically clever move to wait till the closure of the state's case. And of course, let me repeat, it was also a strategically clever move to wait till the closure of the state's case and co-accused cases before spilling the beans and revealing a defense of necessity in the form of compulsion or duress. Any reliance on this defense is rejected. And she is guilty of all the crimes, and she should be guilty of all the crimes that she's charged with. There cannot be any dispute that Jared was initially strangled and then placed in the Mercedes-Benz where he was set on fire. His body was charred, and common sense dictates that even if he had survived the strangulation, that he died in the said motor vehicle. The submission made by accused number 1's counsel that there was no further evidence led that the body did not sustain injuries when it was taken for a post-mortem report is rather an odd and strange submission, and needs not be entertained. The same applied to the doc identification by Joshua Groenewald, because accused number 1 testified that when he saw Joshua Groenewald in court, he realized that he'd seen him in 2013 for business purposes. It is therefore clear from the evidence led that all the crimes were planned by accused number 2. In some cases, she had provided the weapons, and after the crimes were committed, the murderers went back to her and reported what happened. He had always received the proceeds of the crime. There was therefore prior agreement with her about what was going on, what was going to happen. She had associated herself with the perpetrators and had made common cause with them. She therefore had the necessary mens rea like the others. Can the 3 accused stand up? Based on the evidence placed before me, I am satisfied that the accused are found guilty on the following charges. Count 1. All 3 accused are found guilty of count 1. Count 2. Only accused number 1 is found guilty of count 2. On count 3, all 3 accused are found guilty of count 3. On count 4, all 3 accused are found guilty of count 4. On count 5, all 3 accused are found guilty of count 5. On count 6, accused 1 and accused 2 is found guilty of count 6. On count 7, accused 1 and accused 2 are found guilty of count 7. On count 8, all 3 accused are found guilty of count 8. On count 9, all 3 accused are found guilty of count 9. On count 10, all 3 accused are found guilty on the main count. On count 11, all 3 accused are found guilty of count 11. On count 12, all 3 accused are found guilty of count 12. On count 13, all 3 accused are found guilty of count 13. On count 14, accused 1 and 2 are found guilty of count 14. On count 15, accused 1 and 2 are found guilty of count 15. On count 16, accused 1 and 2 are found guilty of count 16. On count 17, accused 1 and 2 are found guilty of count 17. On count 18, accused 1 and 2 are found guilty of count 18. On count 19, accused 1 and 2 are found guilty of count 19. On count 20, accused 1 and 2 are found guilty of count 20. On count 21, accused 1 and 2 are found guilty of count 21. On count 22, accused 2 and 3 are found guilty of count 21 of count 22. Accused 1 is found not guilty of count 22. On count 23, accused 2 and 3 are found guilty of count 23, and accused 1 is found not guilty of count 23. On count 24, accused 2 and 3 are found guilty of count 24, and accused 1 is found not guilty of count 24. On count 25, accused 2 and 3 are found guilty of count 25, accused 2 and 3 are found guilty of count 25, and accused number 1 is found not guilty of count 25. On count 26, accused 2 and 23 are found guilty of count 26. Accused 1 is found not guilty of count 26. On count 27, accused 2 and 3 are found guilty of count 27. Accused 1 is found not guilty of count 27. On count 28, accused 2 and 3 are found guilty of count 28. Accused 1 is found not guilty of count 28. On count 29, accused 2 and 3 are found guilty of count 29, and accused 1 is found not guilty. Am I making this? Magdalene? What look at the group? Okay. Let me just repeat on count 29. On count 29, accused 2 and 3 are found guilty of count 29, and on count 29, accused 1 is found not guilty. On count 30, accused 2 and 3 are found guilty of count 30, and accused number 1 is found not guilty of count 30. On counts 31, accused 1, 2, and 3 are found guilty of count 31, and on count 32, accused 1, 2, and 3 are found guilty on count 32.
As it pleases the court.
Should we adjourn until tomorrow?
As the court pleases.
This court is adjourned until tomorrow, and the accused will remain in custody.